Welcome to today's webinar titled Dealing with Do-It-Yourself Clients. I'm glad you're here. My name is Linus Sujas. I am a senior consultant with Advanced Underwriting Consultants. We at AUC answer tax and technical questions posed by life insurance producers and financial professionals every day. Both Jennifer and I are at AUC are lawyers, and we both have backgrounds working with real clients on estate planning and tax issues. During the next 10 minutes or so, I plan to draw on my own experience to hopefully make the information that I present relevant to you. Let's go ahead and before we get started, let's talk about the topic that's coming up in July. We hold these webinars on the first Wednesday of every month, and the next one will be on Wednesday, July 2nd at our normal time, 11 o'clock Central. The topic will be the complex world of modified endowment contracts, MECs, the complex world of MECs. You are welcome to join us. It is free of charge. It is open to life insurance professionals and financial professionals who would enjoy the content, and so feel welcome to invite any colleagues that you feel might benefit from the topic, the complex world of MECs. Wednesday, July 2nd, 11 a.m. Central. All right, let's go ahead and move on. We're going to talk about four main topics today. We're going to talk about DIY clients, do-it-yourself clients. We'll talk about the motivations as to why clients might choose to do things themselves. We'll talk about the areas in which clients are likely to do things themselves as an alert to you about those areas. We'll talk about some real examples, real life problems that Jennifer and I have actually seen where a client doing things themselves created problems and undesirable results. And then we'll give some brief recommendations for what you might do when a client wants you to help them with a financial do-it-yourself project. So let's go ahead and talk first about motivations, why clients opt to do things themselves. And I think their motivations in large measure might be similar to our own motivations when we try to do things ourselves. Think of a home improvement project. The first motivation is do-it-yourself planning is perceived as being less expensive than hiring a professional. For financial deals, a professional might be lawyer, accountant, or a financial team. In a home improvement project, it might be a construction worker or a plumber. While a do-it-yourself work can be less expensive than hiring a professional, it can also be more expensive when there are unintended consequences, unexpected difficulties as part of the process, things that we or our clients haven't run into before. We can end up really getting into trouble when we try to do things ourselves, and we'll see some examples of how that might apply in the financial world in a minute. A do-it-yourself person is likely to believe they've got greater control over the results when they do things personally. And again, that may or may not be true. A do-it-yourself person may make mistakes in the process that end up to unexpected results. And if we're talking about a home improvement projects, usually the mistakes and their consequences are seen right away. With financial stuff, a lot of times where mistakes aren't revealed until later on, and the consequences to family end up being really severe. Again, we'll talk about examples of that in a minute. And many of our clients have what I would characterize as an irrational fear of lawyers, of accountants. They're intimidated by the process of hiring them and working with them. Um, and that makes sense. You know, even though I am an attorney, I understand why it is that folks might be intimidated by the process. So in any event, that's what it is that our clients are looking at when they might be motivated to do-it-yourself planning. Might be fear, might be objectives that they're trying to achieve by doing things themselves. So let's talk about the kinds of places where clients are likely to try to do things themselves or where they might make mistakes. One of the things that Jennifer and I run into often is tax preparation. Clients get tax preparation software and then get overmatched by some of the details associated with doing their own tax preparation, and they make mistakes, or they don't understand what the software is trying to tell them about how to do things, and they ask for help. And the problem, of course, with a financial professional providing that help is that all of a sudden the financial professional may be getting shoehorned into acting as a CPA. And so those situations can certainly create some difficulty. Financial professionals can also get stuck into post-death management of situations. Makes sense that an insurance professional would be involved with trying to collect the death benefit under a life insurance policy, for example, and that's part of the post-death management process. But a lot of times we're asked to get involved in the administration of an estate or answer questions about estate management where there's a trust as beneficiary of an IRA, for example. And there are a lot of issues that can come up associated with that. And so it's interesting to try to figure out where the line is between trying to help a client and where we're actually involved in legal advice, where the client's asking us to be involved in legal advice. And so that's another area where clients might try to do things themselves or ask us to do too much. Client might make a beneficiary designation choice that can lead to some trouble. It's a situation where a client might not even think of involving a financial professional or a life insurance professional in changing a beneficiary, but the client can do a lot of damage there by doing things the client's own self, and we'll talk about examples of that. And in my mind, the place that's probably the most problematic is where a client tries to do a will or a trust on their own and create some problems. So let's talk about some examples where those things do end up causing problems for the client. Self-made will situation. Here's an example taken from real life when I was back in the private practice of estate planning law. I've changed the names, but we've got a situation where Julie and Tom were married for 12 years. Tom died. Tom was a big believer in doing things on his own, so he got some software and prepared his own will. Inside of the will, Tom created careful language to create a testamentary trust for the benefit of his young kids. Well, after Tom's death, Julie discovered that all of the family's resources that had been generated during the marriage were directed to the testamentary trust rather than to Julie herself. And Julie was not directly financially supported by the assets in the trust, except that she could ask for reimbursement for expenses related to raising the children. That was a problem. Julie was not financially secure on her own, and the shape of the estate plan that Tom had created on his own didn't provide for her adequately. And Julie, in this case, was sure that was not the result that Tom intended, but that was what Tom had done by trying to do things on his own, and that ended up being a problem. We ended up solving it in a way that was almost okay, but it certainly was harder than it needed to be because Tom did things on his own. He was a do-it-yourself, make-your-own-will guy. Beneficiary designations. Now, I've talked about beneficiary designations and the problems they can create a fair amount in the past, so I don't want to spend a lot of time here. But I do want to make the observation that beneficiary designations, when they're done by the client, are often inadequate or often wrong. And it's not necessarily the primary beneficiary designation that's wrong, but a lot of times client won't make a contingent beneficiary designation, which means that the default is the estate. Well, when the estate's the beneficiary, if the primary is predeceased or the estate's the beneficiary, what ends up happening is that that's considered to be the client's estate that's the beneficiary, and it forces assets that would not otherwise have to go through the probate process. And that's a mistake from my perspective. We want to avoid probate in most cases to the extent possible. Another mistake that people make with beneficiary designations is they make little kids either the primary or the contingent beneficiaries on their financial products. Well, when little kids are the beneficiaries, if they're entitled to money, the little kids can't go get that money on their own. That makes sense. And so the courts have to be involved, which makes things harder and more expensive than they need to be. And so those are a couple of examples of how beneficiary designations, if the clients don't think through those issues, can end up presenting a problem at the critical time. Let's talk about post-death management. Let's talk about Hank, who was older at the time of his death, named his trust the beneficiary of his IRA account. And we've got two kids, adult kids, primary beneficiaries of the trust. We've got Hank's CPA acting as the trustee of the trust, and we've got kids each wanting to go in their own direction. Julie wants her money right away, and Kyle wants to put off getting distributions. And the question is, how do we manage all of those moving parts, particularly if the trustee of the trust is not someone who's experienced in acting as trustee of a trust. I'm not saying that this situation is definitely going to create a problem. All I'm saying is that there are lots of potential issues here. The siblings having different ideas of how this inherited IRA is going to be disposed of, and the CPA being in the middle of it. If the CPA signed up for that, that's fine. But if the CPA didn't sign up for being in the middle of Hank's two children in this case, it can end up being a disaster. And so in a lot of those cases, the parties may end up looking to the financial professional to help sort things out, which is probably a role that's bigger than most financial professionals will want to take on. So that's another potential problem that a client might be facing. So what is it that we actually recommend to clients who are inclined to do it-yourself planning? I think it's incumbent on us to let our clients have a reality check of how do-it-yourself planning can go wrong by sharing specific examples that might be relevant to a client. I think where a client is kind of insisting on wanting to do things themselves, where they get us involved a little bit, I think we want to find out why the client actually wants to pursue do-it-yourself planning and help them realistically evaluate the dangers that might apply to their circumstances, and then ultimately decide that if there are other professionals that need to be involved, attorney, accountant, or agent, right? Who is it that can do the right job, the competent job at the right price? Helping clients think through that and evaluate that properly is a key part of what it is that we do. So in conclusion, I'd like to thank you again for joining us today. Feel welcome to attend next month's session titled The Complex World of Modified Endowment Contracts. That'll be held at 11 a.m. on Wednesday, July 2nd. And if you know of an insurance or financial professional who would benefit from our content, feel welcome to invite them to that session. We archive our webinar content and make it available on our YouTube channel, which is Advanced Underwriting. And the recording of today's webinar will be uploaded shortly and will be made available for viewing by those who go to our YouTube channel. Thanks again for your interest in our webinar series and best wishes for continued success.